And guess number one?
Number one. And 23. And 23.
Number one on the list of Commonwealth versus Venom Security and Protective Services, Inc., 15-11071. Motion?
23.
23 would be Kevin Campbell, 15-11069. Counsel for the record.
Yes, John, identify yourself, correct?
Good morning, Your Honor. John Coffey. I represent Kevin Campbell and Dan filing an appearance on behalf of Venom Security, Inc.
Good morning, Mr. Magistrate. Gabriel Thornton for the Commonwealth. I have previously filed my notices of appearance for both cases, statements of the case, and notices of discovery. We have the pretrial conference reports that my brother is filing now. There's a small amount of additional discovery which I will produce to my brother by 1 week from today.
And I read the list correctly that number one on the list is arraignment. We need to proceed with that.
Yes. But we waived the reading and...
Well, Mr. Clerk, I'll
We'll waive the reading to every single count, so we can put that on the record, so it saves some time.
As to Venom Security and Protective Services, Inc., 15-11071. The grand jury in the county of Suffolk on September 28, 2015, returned indictment 15-11071, charging unemployment fraud 19 counts. You waive the reading
Yes.
and enter a plea.
Yes.
Guilty or not guilty?
Not guilty.
counsel, I'll hear you. Anything you wish to put on the record regarding the arraignment?
No, Mr. Magistrate. There's no request for bail.
And does the matter that's on for pretrial conference today already have a practice on it?
It does, Mr. Magistrate, but we're requesting to keep those dates in place, but also if we could have February 26th, the status, by that time we may have a resolution to the matter.
What is the trial track on the case?
It's, the next date would be
March 30th.
March 30th.
And that's the trial date?
No, that's the midpoint. The trial is 7/20/16.
So would it make sense, you want to put both of that as on for status date in here?
Yes, yeah.
And what's that date?
February 26th.
And would it make sense then to set the same track on number one now, or would you prefer to do that?
Yeah, no, you can set it on for the same track. So it would be, midpoint would be March 30th of 16, final pretrial 7/11 of 16, and trial 7/20 of 16 and 8/06.
For the benefit of the record, the court's ordering the company to recognize a person without surety in the sum of $100 without prejudice. The next date in the matter will be February 26th for status in this courtroom by agreement. The pretrial hearings March 30th in the first session. Room 806 for trial on July 20th and final pretrial on July 11th at 2 o'clock.
Thank you, Mr. Magistrate. Thank you, Mr. Clerk.
Thank you, Mr. Magistrate. Thank you, Mr. Clerk.
dock number 5 on the list, the Commonwealth versus Rachel Bond, 1511293.
Counsel to identify themselves for the record.
Thank you, Mr. Curley, Mr. Magistrate. Assistant District Attorney David Deacon representing the Commonwealth.
Good morning, Jennifer Bond, on behalf of Rachelle Bond.
We'll appoint you, Ms. Bates, as representative for your report. Mr. Deacon, before we begin, as you know, the law requires we make inquiry as to whether or not this incident involved any allegations of domestic violence.
This allegation certainly does not, Mr. Curley. There's a related, a co-defendant case where the issue is a little bit more complicated, but this case does not.
Thank you. Clerk.
Okay, the warrant is recalled. Attorney Bays is appointed representative pursuant to Rule 53. There's a $150 legal counsel fee imposed for the appointment. On December 18, 2015, the grand jury in the county of Suffolk returned 2 indictments. Do you waive the formal reading of these indictments? How do you plead to indictment 1584 CR 11293 001 charging accessory after the fact for murder? As to offense 2, charging larceny over $250.
Mr. Deacon, can you please lay out the statement of the allegations?
Certainly, Mr.
If I may, I would object to this. We're not contesting the bail, and there really is no need to essentially have the Commonwealth poison any potential jury pool with a statement of facts that I can't rebut at this time.
I'll note your objection for the record. I'd like the Commonwealth to let us speak.
Thank you, Mr. Curley. I have filed a statement of the case, which I'll briefly summarize for you, Mr. Magistrate. The indictment alleges that in the night of a day in late May or perhaps early June of this year, the defendant and her co-defendant, Michael McCarthy, were in her apartment at 115 Maxwell Street, apartment 2 in Dorchester. Her daughter, who at that time was almost 3 years old, Bella Bond, according to her statement to the police later, was resisting going to bed, was acting up, as 2-year-old children are wont to do. And she sent Mr. McCarthy into the child's bedroom to calm her down, to try to get her to go to sleep. Mr. McCarthy was gone in the child's bedroom for several minutes, during which time the defendant told police she didn't hear anything. And finally, not hearing anything for some period of time, went into the girl's room to see what was going on. She discovered her child prone either on the bed or on the floor, and Mr. McCarthy sort of half kneeling, half standing over her, moving his arms rapidly in the area of her midsection. When she actually entered the room, Mr. McCarthy reached down toward the girl, the defendant. It appeared to the defendant as if perhaps he was reaching down to pick her up by one arm, reaching down with his arm for her arm. The defendant looked at her daughter and saw that she was gray, and to her it appeared as if her daughter's head was swollen. She told police that she knew immediately that her daughter was dead and went to hold her, but Mr. McCarthy prevented her from seeing her daughter and told her to leave the room, which she did. Mr. McCarthy came out of the room, got a trash bag, actually a contractor's grade trash bag, which was in their apartment, went back into the room, and shortly thereafter came out. The defendant told police that she could tell that her daughter's body was in the bag. Mr. McCarthy placed the child in the refrigerator in the home, in the bag in the refrigerator. And at the time, according to the defendant, Mr. McCarthy threatened her life if she said anything about what had happened. The pair then apparently spent the next 2 to 3 days on what can only be described as a drug binge, during which time apparently when they were somewhat lucid, they discussed what to do. One or the other or both of them devised a plan to dispose of the girl's body. In furtherance of that plan, the two of them went to Mr. McCarthy's father's plumbing shop in Quincy, where they obtained weights that were part of a weight set, a weightlifting set, in the basement that Mr. McCarthy, to digress a moment, Mr. McCarthy had been spending, before he moved in with Ms. Bond a few months earlier, had been spending time living in his father's plumbing shop, spending a great deal of time in the basement where the weight set was located. They got the weights, came back to the apartment where Mr. McCarthy loaded both Bella's body in the contractor's bag and the weights in a duffel bag that the defendant had used for laundry. It's a military-style duffel bag with grommets that hold it closed. And The two of them then drove in Mr. McCarthy's car. Mr. McCarthy was driving to a remote area of South Boston, just across the slip of water from the Black Falcon Ferry terminal. At that point, according to the defendant's later statement to police, Mr. McCarthy took the duffel bag and threw it over a little sort of seawall type thing into the water. Then they drove home. The defendant told police that in the ensuing weeks, indeed the ensuing months, the defendant had essentially controlled her and prevented her from exercising her own free will. Evidence uncovered during the investigation, however, suggests that this is not the case. In fact, it suggests that the defendant regularly went out and about by herself on her business. Text messages between the couple indicate that they continued having a domestic relationship, if not an intimate one. That's not clear. And in fact, the defendant attended a July 25th family reunion in New Hampshire of the McCarthy family and was observed by people there to be conducting herself normally, as she had been by neighbors throughout the summer. Eventually, on June 25th, at least many days, probably weeks after the girl's murder, her body washed up on Deer Island. It received a great deal of media attention as the Baby Doe case because no one knew who she was. At least no one who was investigating her death knew who she was. Throughout the summer, the defendant did not tell anyone about the murder or the disposal of the body until the child's biological father, who had recently returned to the Boston area from down south, began coming to her apartment and asking to meet Bella. He had never actually met his daughter, although he had talked to her on the phone. When he came the first time on September 9th, the defendant put him off, saying that the child was at her godparents' on Cape Cod, despite the fact that her body had actually washed up on the beach almost 3 months earlier. He returned a week later on September 15th, and again she put him off. And by this time he had grown concerned that perhaps DCF had taken custody of Bella, and the defendant was unwilling to admit to that to him. The next day, the defendant had a conversation with one of Mr. McCarthy, her co-defendant's lifelong friends, during which she told him that she was getting clean, and he responded that that was good news because it means she could see Bella, she could regain custody of Bella, because he had been under the impression from both defendant and her co-defendant that DCF had taken custody of Bella. That's what they told him. She broke down crying and said she would never see her daughter again. He told her that, of course, that wasn't true. If she got clean, she would, and she said that Michael McCarthy had murdered Bella. Mr. Sprinsky called his sister immediately, told her what he had learned. She contacted the Boston police, as did, well, the next day Mr. Sprinsky contacted the Mass State Police and gave a statement to that effect. Eventually, on September 18th, on Friday, September 18th, the defendant and her co-defendant were arrested separately, and the defendant gave a statement to the police in which she laid out the information, essentially, that I've just given you. Police investigating the case did a number of things. Among them, they did a second search warrant at her home, during which they brought a cadaver alerting dog. A dog is trained to detect the scent of decomposing human remains, and the dog alerted to the hinge area of the refrigerator in Ms. Bond's home. Additionally, based just on her description of the location where Mr. McCarthy had tossed her daughter's body into the water, police sent a team of divers, state police divers, to look for any remnants of the crime, any evidence of the crime. And within 15 minutes, the divers found on the bottom of the Boston Harbor in that area a duffel bag matching the description that she had given that had two weights in it, or essentially next to it, because it had begun to decay, but two weights, which matched a weight that was recovered during a search warrant at Mr. McCarthy's father's plumbing shop in Quincy. The the indictment for accessory after the fact to murder alleges that the defendant knowingly and intentionally, knowing Mr. McCarthy to have killed her daughter, knowingly and intentionally aided him in concealing that crime from discovery. The indictment for larceny over $250 alleges that between the time of Bella's murder and September 18th, Ms. Bond continued to collect benefits on behalf of Massachusetts Aid to Families with Dependent Children benefits, DTA benefits, approaching $1,400 on behalf of Bella Bond, well knowing that her daughter had been murdered and that she was therefore not entitled to those benefits. And she also spent the entirety, essentially, of those proceeds over the course of those months. That, in sum, would be the facts the Commonwealth would anticipate proving if this matter goes to trial.
And sir, is there a request for bail?
There is, Mr. Magistrate. Bail was set in the amount of $1 million cash in the district court by Judge Kaplanis, which was the Commonwealth's request. It's based on not only the very serious nature of the crime, obviously, and the likelihood of a significant period of incarceration upon conviction, assuming, in fact, that we're able to prove it beyond a reasonable doubt, and we expect that we will. Also, Ms. Bond has had a difficult adult interaction with the criminal justice system. You'll note that she's been arraigned 31 separate times in the criminal courts of the Commonwealth. That's 31 arraignments, not 31 counts, 31 separate arraignments. She has defaulted on virtually all of those cases at least once. In several of those cases, she's defaulted multiple times. These are obviously much less serious charges than the ones she faces now. In the cases where she hasn't defaulted, it appears, though I can't obviously state this for certain, they appear to be charges where she was held, where she was arrested, held, and then was either pleaded guilty or was tried and sentenced essentially to time served or something close to it. So that it appears the cases where at least most of the cases where she hasn't defaulted, it looks as if she hasn't had the opportunity to default because she's been held in custody. It doesn't appear from our investigation of the case that she has any significant contacts with family members in the area. She does apparently originally herald from central Massachusetts. There are some family there, but there's no indication that she has any connection, any significant connection to them. The investigation of this case indicates that the defendants were heavily involved in the use of heroin as well as other drugs, and that therefore Ms. Bond had only recently, only within about 18 months of this crime, secured housing in the Commonwealth of Massachusetts, and that was through public assistance for families with dependent children. In sum, she is a person who has struggled, it appears, with substance abuse and addiction throughout her life. It has led her, or at least contributed to her committing a very significant number of crimes, albeit crimes less serious than this by far. And there is absolutely no reason to think that if she posts frankly, unless the bail is set extraordinarily high, there's no reason to think that even if she posts it, she will return to answer to these charges, which are even more serious than the ones she's previously defaulted on. For that reason, it's the Commonwealth's view that only a very significant bail is sufficient to assure that if she posts it, she will in fact return to answer these charges. That was $1 million cash, that's right.
I'd like to be heard. Yes, we don't contest the bail, and the fact that the district attorney has gone on and on and on is an indication that this case is being played out in front of the cameras for the benefit of a potential jury pool and poisoning any future trial or any chance Ms. Bond has of trying this case with a neutral finder of fact. We dispute the fact that she assisted Mr. McCarthy in any way, and while there can be physical control of a person, there can also be emotional and psychological control of a person. Ms. Bond does not contest the bail. Until she had housing, she'd been homeless for a great many number of years. So the fact is that any bail whatsoever is more than she can meet. And at this point, as I said, I see no reason to go on and on and on. It's simply to poison the public against her. So at this point, I would state that we don't oppose the bail. I'd ask it be set without prejudice, although I don't think any bail would hold her. And I would ask that we set a pretrial conference date, if that's acceptable, of February 26th. There's a great deal of discovery that needs to be reviewed and produced and so forth. I believe that Mr. Deacon and I also have a protective order with respect to some discovery, which I'm happy to sign and to file with the court. And I think that really is about it at this point.
Mr. Deacon, that February 26th date, is that a good date?
Yes, we had actually discussed that date previously. That date is agreeable. There is a matter of setting the tracking order. Mr. Clerk.
Mr. Deacon, I'm advised by the clerk, this matter will be assigned to courtroom 906, which would have its pretrial matters on either Tuesday or Thursday at 2
Oh,
p.m.
all right.
Oh, maybe the 25th.
25th at 2 p.m.?
Very well. And what I think we'll do is we'll set the matter down for a pretrial conference there, you say February 25th.
That's fine.
And you can address the trial track with the judge in that session.
That
Thank
sounds
you.
good. Thank you.
And I think we'll file the protective order here.
Yes,
Is that
if you want.
acceptable? All right.
Bail's now set in the amount of $10 million with surety or $1 million cash, set without prejudice. You're advised to be able to post bail on a charge of a crime during your release. Bail may be revoked in accordance with general laws, chapter 276, section 58. You'll be transported on February 25 to a pretrial conference center set to track in room 906 by agreement.
My client has asked me to waive her appearance on the 25th.
In that case, Mr. Clerk, we will note on the docket that the defendant premises waived her request. The counsel are told we'll take that protective order and endorse it as allowed.
Thank you. Thank you.